to talk about recent findings on the Reg BI examination and enforcement front, what you can expect following the PTE 2020-02 deadline, and much, much more. A few quick housekeeping matters before we get started. We are recording today's conversation and plan to share it with you following today's session. We sincerely appreciate your engagement throughout today's conversation. Please leverage the Zoom chat box at the bottom of your screen to submit any questions you may have throughout today's conversation. And we are predominantly, maybe minus Josh and David, we are going to be working from home, so you may hear some background noise from time to time. We appreciate your patience. So to get things started, I'm going to ask our all-star and esteemed panelists to introduce themselves, starting with Mr. Craig Watanabe.
Well, thank you, Faram. It's a pleasure to be here. My name is Craig Watanabe. I'm the Director of Investment Advisor Compliance at DFPG Investments LLC, based out of Salt Lake City. We are a mid-size dual registrant.
Thank you, Craig. Mr. Porteous, do you mind going next?
Yes, my name is David Porteous. I'm a partner at Faegre Drinker in Chicago. I work in the investment management and business litigation groups. I specialize in working with broker-dealers and investment advisors in their operational mechanics, regulatory compliance, and enforcement matters.
Thanks, David. Josh?
Hi, everyone. My name is Josh Waldbeser. I'm like David. I'm also a partner at Faegre Drinker here in Chicago. I'm sort of duly aligned with the benefits and executive compensation group, the investment management group. And the main focus of my practice is on assisting financial service providers of all stripes, investment advisors, fund families, broker-dealers, dual registrants, insurance companies, and so on with compliance with ERISA and all things in the retirement world.
Mitch?
Hi, I promise you I'm not impersonating Jeffrey Wilk. What it says on the screen, my name is Mitch Atkins. I think that's just a typo. I was with FINRA for 20 years and did just about every job in the district office structure, worked on special projects, special investigations, and then went up to run the Long Island office. After that, became the director of the Florida office and ultimately the regional director for the Southeast United States. After that, I started consulting, and I have my own consulting practice based in Boca Raton, Florida. And my focus is broker-dealer compliance consulting. I do a lot of work with Reg BI, starting to do a lot of work with the DOL PTE now, and a whole variety of things in the BD consulting world.
Thank you very much, Mitch, and my apologies. My name is Parm Nasseri, Head of Regulatory Strategy here at InvestorCOM. InvestorCOM, if you haven't heard about us, is a leading software provider across North America, and our award-winning platform is best recognized for its intuitive design and focus on mitigating compliance risk. Let's jump into the agenda for today. The focus of our multifaceted conversation will be to talk about all things examination and enforcement front on the Reg BI and Department of Labor side of things. We'll explore leveraging regulations like these topics as a core component of your firm's growth strategy, as well as sharing practical insights on very important topics such as education versus recommendation, rollover recommendations, account type recommendations, and all things retrospective review. This is going to be very conversational, folks. Please engage, ask our esteemed panelists any questions as we get into the thick of things. Before we jump into the conversation, over the course of the Reg BI and PTE 2020-02 journey, we brought the wealth and compliance community together to better understand how you and your peers are tackling these very core requirements. Ahead of today's webinar, we polled our respective audience and asked, what are you finding most challenging? And observe that when compared to the same poll question that we asked in March 2022, disclosure and documentation, and specifically the retrospective review process, as you can see on your screen, has been taking a lot of headspace for folks. It is a growing trend of concern for folks and a challenge. Sort of topical given the June 30th deadline. In addition, we asked about the manual versus technology first approach to making best interest rollover recommendations. As you can see, that compared to the March data, there is a little bit of a dip in terms of the figures of folks tackling this manually using PDF or Excel spreadsheets or paper-based approaches, and an uptick in terms of folks leveraging technology, which is certainly encouraging, and we'll talk about that a little bit later today. On the Reg BI enforcement expectation front, this number has remained fairly static for us that we've been garnering throughout our travels in the industry. Clearly, this assessment of reasonably available alternatives continues to be top of mind for folks in the industry, as well as rollover recommendations. Okay. Now, final piece of the pie really is around how are firms tackling the reasonably available alternatives requirement. As you can see, close to 50% are using a template. Some folks in the industry are using technology solutions. Meanwhile, others have basically not actioned that requirement necessarily. One more data point that I found interesting, and it's foundationally around how you plan, how firms or financial professionals endeavor to meet the retrospective review process. As you can see, 57%, almost 60% of respondents indicated to be taking a manual audit approach to meeting these requirements. So for our lovely panelists, this is going to give us plenty to talk about, and let's just jump right into this. There has been plenty of market fodder, including yesterday's SEC notice that we were just chatting about, around focus on the conflicts of interest element of regulation best interest. So Porteous, maybe I can start the conversation with you to see, with all the rhetoric we've seen in recent cases, specifically on the Reg BI front, what do you see as being a main concern from the SEC's perspective? Or maybe I should even focus on FINRA as well.
I think I go back to something that was asked of Chairman Gensler at the SEC when I think he was coming on board, as to whether and to what extent he contemplated making some revisions or changes to Regulation BI. And I believe at the time frame he had said something to the effect of, we're going to enforce it as written. It's got some teeth to it, particularly in terms of variety of requirements that firms are expected in order to be able to demonstrate that they're acting in their clients' best interests. And so we'll see how we go. And I think what we're now seeing is the culmination of that principle, which is, there are books and records requirements tethered to Regulation BI. Hence, you see the Form CRS cases where firms couldn't allegedly get their Form CRS out the door on a timely basis, or it had inadequacies in its disclosures. You roll forward from that, and talking about like your graph demonstrated a minute ago in terms of reasonably available alternatives. How did you document it? What was the basis of the recommendation? And the Regulation BI states that you don't have to have documentation per se for every single recommendation. It's a risk-based approach, but just the slide you have up here demonstrates that nonetheless the enhanced complexity of a recommendation, let alone a specific financial instrument, carries with it additional burdens and responsibilities in making those recommendations in the first instance. And how do you document the principles underlying the recommendation if you don't have the paperwork? And so I think seeing that kind of coming into action, whether it's in exams, it's in the alert that went out yesterday that the SEC put out on conflicts of interest and the expectations of broker dealers and investment advisors. At its fundamental core, it's taking the rule as written and saying, look, we meant it when we said it. We expect you to have good policies, procedures, practices, and a thoughtful approach to the conflicts of interest inherent in the nature of your client relationships, whether it's on the broker-dealer side for BI purposes, or under the Advisors Act as a fiduciary would otherwise have as part of their duty of care to make sure that you're acting in clients' best interest. And how do you do that if you don't document it? And what your basis of your recommendation is, and how your policies and procedures work in the training. So I think it's everything and nothing simultaneously, right? They meant it when they said it. They're going through, and I think the alert that came out yesterday is a good example of, these are all touch points for purposes of an examination, for purposes of self-reflection, for purposes of internal audit and analysis, and as purposes of supervisory review and compliance, to make sure that, hey, have we thought through these issues in the way that they're articulating? And I think these enforcement cases are form follows function.
Thanks, David. Mitch, maybe I can ask you from as an ex-leader in the FINRA division. I'm wondering if you've caught the recent arbitration cases that have you really poked their head out around Reg BI. Any thoughts to share from a FINRA perspective?
Yeah, at first I was a little surprised that it was that low on the list, meaning the number of claims related to Reg BI, and I would expect to see them much higher on the list as we go forward. But it does take time, whether in the FINRA enforcement space or in the arbitration space. It takes time to detect a problem, to go through and develop a case, prepare a case for filing and all of that. So I suspect that that's part of what it is, the newness of the regulation. But I fully expect that this will become one of the top, I would guess, top 3 or 4 items on the top 15 list of arbitration claims. And I agree with what David said, and I think in addition to the regulatory space that he was talking about, in the arbitration space, this gives a very powerful tool to plaintiffs' attorneys. A suitability case was always somewhat difficult. There were challenges. FINRA or plaintiff's attorney can bring a suitability case, but it wasn't always a slam dunk. And I think with Reg BI, in terms of bringing a case for a failure in that area, there are things in Reg BI that make it a much more powerful tool. So I think if the plaintiff's attorneys find that there is a violation of one of those requirements, or they want to allege it, I suspect that they want to include that as much as possible because it strengthens their case.
Yeah, I often wonder about kind of the jurisdictional challenges between the SEC and FINRA advisory versus the brokerage side of things. And David, rollovers, in a way, the advice centered around rollovers seems to kind of intersect those particular segments of the market. If you had this magic ball that you could sort of see the future, how do you see, or what do you think the drivers are around the regulatory scrutiny around rollover specifically?
I think what we're really seeing is a convergence between, if you may recall, the sequencing here is that the SEC came out with Regulation BI, and in the adopting release, they made clear that the decision whether to roll over out of an IRA, out of an ERISA plan into an IRA, or to open any other type of account is a significant recommendation that needs to be included as part of the best interest analysis. And then DOL came out with PTE 2020-02, for which the sort of the final enforcement date and documentation went into effect as to July 1st and even prior, as Josh can expound upon. And my point in mentioning the sequencing of that is there's really some convergence going on between the DOL rule and I think the SEC's enforcement and explanation reflected in their staff bulletin yesterday, which is, disclosure is not a panacea for everything that is that you do. You may have conflicts of interest that just aren't sanitized simply by disclosing something. And I think this is something, talking to my colleagues in our ERISA group like Josh, who always remind us, saying, look, a prohibited transaction is a prohibited transaction. If you're doing something in violation of ERISA, there's no amount of disclosure is going to cure that. And I think that that's where I'm seeing like this staff bulletin that came out, reinforcing that, hey, just because you disclose something doesn't mean that you've actually done something that's in somebody's best interest. So I think that taking that principle and applying it to the rollover space and saying, look, both BI, the Advisors Act, and ERISA are all focused on rollovers as a type of transaction or service or offering that needs to be thoughtful and done in somebody's best interest. And how do you go about documenting it? And I think that that's where, peering into the future, we're going to continue to see, where firms have gone about implementing programs for purposes of PTE compliance. It was also already part and parcel of the analysis they had to undertake for BI or under the Advisors Act, depending upon what type of institution they are. And so you're going to see a focus, whether it's coming out of the bases, the principle by which the examiner is asking the questions is based on BI, or it's on the Advisors Act, or it's based on ERISA, which raises some jurisdictional issues. It's going to be the same questions as to what's the efficacy of your program and your supervisor procedures and controls for purposes of a rollover recommendation, and how do you go about documenting it? And I think those questions cut across regardless of the regulatory source of that responsibility.
Thanks, David. And since you picked on Josh, maybe I can point the mic to you on this. Josh, with the June 30th regulatory deadline behind us on PTE 2020-02, can you provide our audience maybe a brief overview of the why behind PTE 2020-02 and really what the Department of Labor, speaking of conflict, is trying to achieve with these requirements?
Sure, absolutely. And one point I would clarify just up front is that, as David alluded to a minute ago, there's actually sort of two deadlines, if you will, under PTE 2020-02. The general compliance deadline was back in February of this year. What was pushed technically was the requirement to document and to disclose to the investor the reasons why a rollover recommendation was in that investor's best interest. And basically the way that the DOL did that is that they adopted sort of a non-enforcement policy on that specific part of the PTE until June 30th. So in a very real way, July 1 was a watershed date for the industry. The short answer is that this PTE 2020-02 is in a very real sense a replacement for the Obama era best interest contract exemption. Those of you who went through the Obama era fiduciary rule, because when the Fifth Circuit struck down the fiduciary rule, with it went the best interest contract exemption and all the other changes. And since then, during the interim period, we were kind of living with temporary guidance, like a temporary non-enforcement policy that the DOL and the IRS, with respect to IRAs, had issued to sort of just carry the industry through while they could promulgate final rules. And PTE 2020-02 was that final rule. Of course, there's very much a focus on rollovers, given the timing and the retirement of the baby boomer generation. Just the sheer amount of money that's moving out of plans and into IRAs is massive and mind-boggling. And regulators, particularly the Department of Labor and the IRS, were subject to heavy criticism over the years for not regulating the rollover process more. Under prior DOL guidance, sub-regulatory guidance, basically rollover recommendations were usually not considered fiduciary advice, so they didn't trigger the ERISA requirement, they didn't trigger the prohibited transaction exemptions, and the DOL did kind of an about face on that and changed its position informally along with the PTE. But the DOL had been criticized by the Government Accountability Office going back a couple decades, actually, for not doing a better job of regulating rollover recommendations. So to briefly wrap up the question, which is a great one, PTE 2020-02, again, is to replace the best interest contract exemption. You might recall that it was actually issued and proposed under the Trump administration, and it was allowed to go through and to be finalized under the Biden administration. And I think what that reflects is that it is viewed as a better compromise, if you will, than the best interest contract exemption, or at very least, maybe for right-leaning administrations, it was considered better than what, or less arduous for the financial services industry than what a more left-leaning administration might have done, sort of left to its own devices. So.
I was hoping Craig would jump in with a few questions pointed at you at this point, but let me ask you, Craig, just to kind of opine on this from a firm specific perspective. You obviously are a leader in the industry from a in-house perspective, and what do you see as a maybe a formidable challenge, given the data points that we saw off the top, and given the set of requirements that were actually in play that were due by June 30th? Do you do you anticipate that the data points are true and firms are 50% of firms are actually tackling this manually?
Yeah, absolutely. And if I can take a step back, just some foundational comments that I want to make with regard to the rulemaking. From the industry perspective, these two rules, Reg BI and the DOL reinterpretation of a fiduciary, along with PTE 2020-02, they represent some changes, something different, something that we haven't had to deal with before. And anytime you introduce things that are new, that presents challenges to the industry. So in particular, you would think that a suitability determination would be very similar to a best interest determination. And if you think about suitability, we consider factors such as age, income, net worth, investment objective, risk tolerance, investment experience, and so forth. But under Reg BI and the PTE 2020-02, we have to consider things like readily available alternatives. We never had to do that before. We have to consider a side-by-side cost analysis. We never had to do that before. We have to provide a rationale as to why the recommendation was in the best interest of the investor. We never had to do that before. And those things all being new and present significant challenges for the industry. And so I think that, when I think about those challenges and how to tackle them, I want to take first the best interest rationale. One thing that I would suggest that everyone do is become familiar with the SEC's first enforcement case announced just about a month ago, and read that litigation release. It's very educational. But one of the things that I picked up from that litigation release is the SEC presented the fact patterns of 8 anonymous clients. And in all 8 cases, they cited as a deficiency the firm's rationale for best interest. And instead of a rationale for best interest, the firm was citing a rationale as to why the transaction was done. So for example, the client wanted higher interest than they could earn in the bank. That's why we did this unrated higher yielding bond, right? That's a reason why you did the transaction. That is not a reason why it's in the best interest of the client. And that little subtle difference between rationale as to why you did the transaction and why it's in the best interest is something that I didn't fully appreciate until I read that litigation release. And so, what I did is, had to go back and do some testing and try to, make sure that we were very careful when providing the best interest rationale, that we were truly addressing best interest and not just a rationale as to why we did the transaction. The second thing that I wanted to point out, and this I knew a long time ago, and that is the most challenging aspect of meeting the PTE 2020-02 is going to be the cost analysis. And if you look at the DOL's FAQ, in the FAQ, they suggested that, to do the cost analysis, you should ask for the 404A5 disclosure. And if you can't get that, you should get a Form 5500. And if you can't get that, then you can use benchmarking data. Well, I was a retirement advisor for a number of years, and I was the CCO of 2 retirement advisory firms. So I know those documents really well. And when I read that, I said, there's no way. First of all, you're going to have a really hard time getting them. Second, even if you get them, the advisors aren't going to be able to provide the data that you want. So here's the challenge that I make to everyone. Go on the internet, do an internet search, pull a random sample 404A5, pull a random sample 5500, and you try to extract the cost data. My guess is that most likely you won't be able to do it. And if you can't do it, then why write a policy that your firm is not going to be able to execute? And that is why we have seen an entire industry of automated solutions built to help address this issue, because computers are good at two things. One, they're good at managing large amounts of data. Two, they're good at calculations. And so when you talk about this cost comparison, computers are really good at that. And these automated solutions offer some really wonderful solutions and a significant path forward. One last comment is, and this is a suggestion, that I know that you've probably already implemented as the deadline has passed, but I would say this: if you haven't done due diligence or looked into any of the automated solutions, even if you have no intention of doing so, I think it's very educational to look into a solution like what InvestorCOM offers. I learned a lot in looking at how various vendors have approached this situation, tried to provide solutions. And what was remarkable to me was how different the various vendors were. I think if you look at some other compliance tasks, one vendor to another, their solutions all look pretty much the same. Not the case with Reg BI or PTE 2020-02, very different approaches. And so I think it's worthwhile to try to learn from those automated solutions. So those are my comments. Thank you, Parm.
Craig, can I just, Parm, if I can jump on something Craig said, and I saw this with a number of firms that we've advised on, in the first instance, helping them with, let's say, a manual form that they were going to provide to client in the recommendation process, whether it's reasonably available alternatives or otherwise. And I think the point Craig was making about the case, which I just circulated a link about, so take a look at the chat box, has a hyperlink to it, but the name of the firm was Western International Securities. But I think the point that Craig was touching on goes to what I have historically seen a lot of firms would have, going back some years, looking at the level of documentation expected if you were going to back up a suitability recommendation, saying, okay, why does client, why are we making this recommendation? And you'd say, well, client was trying to achieve something like Craig just described occurred in the Western International case, right? There's some objective that that someone has articulated, saying, hey, I'm trying to do X, Y, Z. And then, maybe the representative has provided a description saying, well, consistent with that objective, here's some different options available to you. And then you'd see in a text box or a text field or an email, whatever the firm's system may be for backing up some bases for a recommendation, where it would say, well, this is what the client was trying to achieve. And we talked about a couple of different products. And so, this seems to be closest to what client's trying to achieve. And I think whereas maybe that cut the mustard or not, or certainly that was pretty consistent with what a lot of people are doing on our suitability style analysis, where I think best interest heightens things is to say, yeah, but where is the subjective statement of the firm's own belief and the representative's belief as to why that recommendation, why a couple of the three different products that you discussed with the client, how does that meet that objective? How is it ultimately appear to be in their best interest that this specific product you're recommending not only achieves that objective, but as compared to some other alternatives you may also have explored with them, that this one seems to be best. And so I think that the departure point is moving from sort of, okay, this is what the client said that they wanted, that's great, but just because the client said that they wanted, they may not appreciate that going naked puts and calls was really in their best interest given their stated strategy, objective, time horizon, liquidity needs, and all the other suitability factors. So our recommendation was not to do this aggressive strategy, but rather to do something else. So it's going beyond simply relying upon what the client has said that they want, and that seems good enough, versus what is the firm's own subjective opinion as to why a particular course of action is or is not in their best interest. And I think that's what the migration or the evolution of the explanation needs to be focused upon. Why do we think, even if the client wants X, Y, Z, or a client has a specific objective, what is your subjective opinion as to why this is or is not in their best interest?
Thanks, Dave. And I completely agree. There's Craig said it really well. It's trying to articulate and document why it's in the investor's best interest, as opposed to why is this the right suitable product for the client. So it does go beyond the simple sort of the traditional suitability requirements under FINRA. And speaking of FINRA, Mitch, maybe I can point the mic back at you. You've been involved at the intersection of regulations and helping wealth firms amongst clients through this digital journey or digital transformation journey and regulatory adoption journey. What top of mind tips and tricks would you have for firms who are looking at things and saying, hey, maybe I should start with manual and maybe transition to a technology-based solution down the line?
Yeah, I mean, I think that's evident if you look at your survey results at the beginning of the webinar. I mean, that's actually what people are doing. And I think the truth is that the regulators are evolving a little bit too as they go along. You know, whenever there's a new rule that comes out, typically regulators will go out and they'll look at what the firms have done and they'll separate them and say, you know, I like what these 10 firms did. I don't really like what these 10 did, and the ones in the middle, it's okay, right? And then they start to focus on what the ones that they thought did a great job have done, and then they start to, their guidance will start to evolve. And I think we're seeing that in terms of the staff bulletins and what's coming out and the additional clarifications. I think firms have to adopt that mentality that if they took the time to write procedures for Reg BI or DOL, and they developed a few forms and they said, we think this is going to do it. We check that off. We're finished with this project and we're moving on. I think Craig said it well in saying that at least for broker dealers, these two requirements are different. They're basically making them work a different muscle than they've worked before. And they're having to design systems to do things that they haven't had to do before. So I think it's really important, if you're listening today, to take to heart what folks are saying about the requirements, because it really is different than suitability. And what is in the best interest of the client and how that's documented is going to be really, really important going forward, both to defend yourself in an arbitration, to satisfy the regulators, and to do the right thing under the regulation. The other thing I'll mention is, you know, a large firm has the scale to put, you know, to invest in top-notch technology that can make this very easy, that can help people save time and those things. Sometimes that gets more difficult for smaller and mid-sized firms. And I think to some extent, small firms are driven to the manual processes because you know, they don't have the budgets for some of the technology providers. So hopefully there are providers out there that will be, you know, working on an affordable solution for the smaller firms, maybe based on their scale or however it may be. But I, you know, I think that's one of the things that some of the smaller firms struggle with. So if you're in that, you know, if you're in that large firm group and you have the resources, I think the writing's on the wall that it makes sense to invest in the technology to the extent that you can. And it pays off. The larger you are, the bigger the scale, it makes sense. The smaller firms are really going to have to look at a cost-benefit analysis in terms of the amount of time that they're expecting their representatives to spend. I think, you know, what was just said about the, you know, registered rep going out and searching on the internet for one of these forms and finding the costs and actually putting it into a comparison spreadsheet or form and doing it correctly. We're already seeing in doing the Reg BI reviews and the rollover reviews, we're already seeing significant variations in terms of what the representatives are doing, in terms of quality, in terms of covering all the required bases. It's really, really hard. I'd say it's like, in some ways, I don't remember the consulting firm that used this, but it made sense, herding cats. You know, it's really not a skill that representatives have dealt with. So so I would say that, yeah, Param, I agree. I think in many cases, technology is going to be the answer. If technology is out of reach for you or your firm, I think it's really important to invest some time and effort in a really good set of forms that will drive the user of those forms to the correct outcome. And sometimes that means leaving less of an opportunity for free form text and language and putting some structure around it.
Thanks, Mitch. That's certainly insightful. Maybe in the interest of time, let me just make a quick public announcement, folks. If you're hearing our panelists' commentary and you're wondering, what about X, Y, and Z, please send us questions. We have allotted 15 minutes at the end of today's session to tackle as many of those in a fire boat round as possible. Now, segueing back into our kind of conversation, and maybe Craig, just piggybacking off of this point that Mitch just made around, look, you need some degree of consistency and standardization across an organization. As someone who's been a leader in the compliance community for some time, what approaches do you believe will be most beneficial and practical for our audience today?
Yeah, I think that's a really good question. And the way I approach automation in general, whether it's specific to Reg BI or PTE or automating anything else that we do in compliance, I think it's always really important to have a solid foundation and a good understanding of the basic policies and procedures. If you try to look to automation as a shortcut to provide those policies, procedures, and workflows, I think you're potentially looking at a mistake. Whereas if you have a really solid foundation on policies and procedures, you have manual workflows, and what you're simply looking to do is automate those, I think you have a much better chance of success when implementing that automated solution. So that's number one. In terms of consistency, I think it's a difficult question because, as we know, every firm is different. One size does not fit all. Whereas I think what Mitch said is absolutely true, totally agree. Larger firms, automation makes total sense. Smaller firms, it doesn't. Well, what about firms sort of in the middle, right? And every firm is going to be different. So I think that ultimately what firms need to do is hopefully they have a good understanding and they have their arms around the basic policies and procedures surrounding what they're trying to achieve. Then they take it the next step and look at, well, what are the benefits of automating some of those policies and procedures? And then they're able to make an evaluation based on all the relevant facts and circumstances surrounding their particular firm and that implementation.
Thanks, Craig. And let me say this is sort of a side plug for our solutions, but I think you mentioned kind of flexibility and ability to have a technology-based solution that can adapt with the firm's policies and shifts in policies and procedures. And I have this on the screen, but just about everything on this form is configurable and allows the firm to sort of evolve their practice as they go. The reason this plug kind of plugged into my mind is I saw a question come up, and Josh, maybe I can point the question your way because we had already chatted about this notion around, listen, what if we just take an education-only approach to making rollover recommendations versus truly defining them as a rollover recommendation? What are your thoughts on that topic altogether?
Sure. And that's a great question. And let me say, in dealing with clients, I've seen both approaches taken. And more specifically, I think that there's a general appetite in light of the PTE to reduce the number of instances where you have to go through the full best interest analysis and documentation and so on. So, which is another way of saying that some firms are going to an education-only approach. I think that that's predominantly smaller firms, in my experience, that are doing that, and actually prohibiting advisors on the ground from making per se recommendations. And others are, more like larger firms are maybe more likely to be implementing policies and procedures and forms to do recommendations, but also encouraging the use of education and non-recommendations where possible, and to reduce those pain points. And I think that both approaches are perfectly viable. Let me say that, at very least in theory. I would say though that to the extent that you're going to rely on education, whether it's entirely education or just partially education, you want to be very careful that you're developing written materials, maybe even scripts for advisors that are truly neutral and extremely unbiased, not at all reflecting any sort of unconscious bias toward an IRA rollover. And certainly, then maybe this is too obvious to point out, but the education-only approach cannot be used as a cover to make sort of implied tacit recommendations. To hand someone an educational document and say, this goes through the pros and cons, but if I were you, that's a recommendation. You've certainly crossed the fiduciary threshold there. And what I would say is sort of 2 points is that it's all well and good to come up with policies and procedures and rules for this, but you really need to think through what's going to happen on the ground and what's practical. You have to consider what's going to happen behind closed doors, with an advisor dealing with a client that they've had for years and trust them. Are they really going to stay on the right side of it if they're not making a recommendation? And also, just as a very practical matter of risk mitigation, if you're not making a recommendation, whether it's a purely unsolicited rollover, say, someone comes to you and says, look, I just left my job, like you guys, trust you guys, want you to manage this money, real unsolicited rollover, or whether it's unsolicited but with education, I strongly recommend that you get the investor's signature on it, whether it's an account opening form or a standalone acknowledgement that very prominently highlights the fact that this was an independent decision, that the advisor did not make a recommendation. It doesn't mean that they could never come back and say that wasn't true, but at least gives you some contemporaneous documentation that no rollover recommendation was made. So,
now I want to take the other side of that argument, because I'm going to point to the DOL's FAQ, question number 8, which I consider to be a shot over the bow. The DOL basically said you can't disclaim your way out of compliance with this rule. And the way that I wrote my firm's policies and procedures, if you go through the various machinations and myriad of possibilities of when this rule applies, when it doesn't, it's extremely complex, really complex. And to make it all simple, my firm's policy and procedure is, if you open a retirement account, you have to do the PTE policies and procedures, period. Made it easy, no brainer, right? You don't have to think about it. It's just a really easy solution. Now, granted, there's going to be some cases where maybe we didn't have to comply, but I was willing to err on that side as opposed to the other side in order to protect my advisors and protect my firm. And so I went with a little broader policy up front in terms of when my policies and procedures apply. And I have no second thoughts about that policy. I think that it was absolutely the right decision, best way to protect my advisors and protect my firm.
What I've heard, Craig, to reinforce that, what I've heard from firms of different stripes and sizes is that at some level, this is a control function insofar as how big, how many representatives do I have? What is the let's just say the sales process? In some institutions, they're very, very soft sell. They have a few advisors, and it's manageable in a smaller institution or a smaller size infrastructure with the number of representatives you have and the number of supervisors you have to say, look, I can manage it. The exceptional circumstance that Craig's describing where, okay, look, we're just going to tell everybody to do it, but realistically, that may happen more often than not. We're not really making a lot of recommendations because that's the nature and stripe of our institution. You scale that up, and you're talking about a supervisory headache of trying to call balls and strikes between circumstances in which people are making recommendations, they're not making recommendations, tracking when we're conducting educational seminars. Are we dealing with a prospective new client who we have no history with, or somebody who already has an account with us? I've heard of some firms saying, look, we'll accept a representation from a representative that I didn't make a recommendation in this context to the extent we have an existing client relationship with this person. But if this is a prospect, forget about it. You better document it. So I think there's a variety of approaches, whether it's prophylactic with the exception kind of approach Craig has, or kind of, we'll go one by one and figure out what the representative believes is the basis for the recommendation, or that they're not making a recommendation, but it really goes to the size and scale of your institution of, do I have the supervisory infrastructure to oversee and capture and feel a confidence level that when I audit this, I'm not going to have all kinds of exceptions or issues that I can't explain. And if your scale is small enough that you can manage it, more power to you. But the bigger that you get, and the more representatives you have, the more recommendations that you're responsible for supervising in real time at the front end, let alone auditing at the back end, and trying to identify how many instances we had where I don't know if this is a good recommendation. I don't know if this is really not a recommendation at all. I don't know if this is education. It kind of comes down to the wieldy or unwieldiness of observing compliance and testing and auditing for it. So it varies by institution.
And if I could just really briefly build on something that an excellent point that Craig made really quickly to clarify. One of the changes, or I would say one of the clarifications that the DOL made with PTE 2020-02 is that written disclaimers, boilerplate disclaimers in investment documents are not going to be dispositive on the question of fiduciary status. If you're familiar with the definition of fiduciary as defined by the DOL, there's a 5-part test, and part of it says that there has to be a mutual understanding or agreement between the parties that the recommendations given are going to be a primary basis for investment decisions. And what DOL has said is that, look, if you have disclaimers in your contracts, we'll take that into account in determining whether that understanding existed, but it's not going to be dispositive. So that was a great point by Craig. Now, if you don't make a recommendation, you're not subject to the rule in the first place. But to David's excellent points, it's really a question of a process and making sure that process doesn't become too unwieldy in and of itself.
Josh, David, Craig, and Mitch, thank you very much. Before we go into the lightning bolt Q&A session, let me just pass it over to my colleague, Mr. Travis Champion, for a quick comment before we go to the Q&A session.
Yeah, thanks, Parham. Craig, Mitch, Josh, David, thank you guys. Fantastic. A lot of questions coming in, so I want to get off here quickly. But from the cases taking time, all the convergence of the regs, all the items that were brought up today, we know this is going to generate a lot of questions. Please, for the attendees, please look out for our follow-up email. In that email will be no obligation trial offers, and we, as always, continue to encourage you to reach out to us with questions, and we look forward to working with you in the future to help satisfy and potentially automate some of these solutions. So thanks again.
Thank you, Travis. And folks, let's jump into the Q&A session. Mitch, this time we got it right. So lots of questions coming in, and I'm going to try to paraphrase to the best degree I can and combine some of the questions. The one that kind of caught my eye early on was when thinking about the 40485 and the Form 5500 information, will there be any, or are you aware of any pending regulations that will require firms to disclose actual fee information in that Form 5500 database in a more transparent manner than it is currently? Josh, maybe this is a question for you. You're on mute.
Yes, the short answer is yes. The DOL has issued rules that would require more transparency as 5500 on a number of fronts. So this is very much going to be a moving target over time. That's obviously a regulatory focus for them. Somewhat to the chagrin of the industry, but in the sense that it does make, in the same sense that it makes this information available to those who would use it for these purposes, it also makes this information available and easily sortable to those who would use it to litigate. But yes, that is something very much, it's an excellent question. It's something very much to keep your eye on.
Speaking of pending regulations for folks on the panel here today, are you aware of any potentially new pieces of guidance coming out from either the SEC or the Department of Labor? We've heard about a December deadline for a publication coming out from the Department of Labor. Any insights on that front? All right, we'll go to the next question. Do you think that the auditors will look for a technology solution that will have built-in implementations around this retrospective review process and weighing the percentages between, hey, what is the fee of this product compared to the degrees of service? Any insights on this retrospective review process? what it will need to look like?
Well, I think there's going to be several approaches. One, a lot of firms are going to fold it into their already required annual review. That's going to be a common path forward for a lot of firms. Other firms, especially those that have adopted an automated solution, most of the automated solutions have already considered this and built workflows to aid in this, including dashboards and statistics and things like that, plus ready access to all of the data, which really is going to be a great aid in terms of doing those retrospective reviews.
Absolutely agree. This may be targeted towards you, Mitch, specifically on the Reg BI enforcement front. What do you expect to see specifically from FINRA's perspective? Maybe kind of piggybacking off of some of the arbitration cases that have kind of presented themselves in that most recent report.
Yeah, I can tell you that my observation just has been that FINRA is very aggressively looking at Reg BI compliance. They started maybe not so aggressively in the very beginning. Now, whether it's Form CRS compliance or reasonably available alternatives and documentation of that, I'm seeing across the board, their questions are getting more in depth. I think now that this new staff bulletin has come out on conflicts, they're going to do the same thing in terms of drilling down into the conflicts for firms that are again the one and done thing. Where you think you've got it, you checked it off. That's not the case with either of these requirements, and I think FINRA is probably, I would speculate that they have a good number of cases in the hopper right now that they are working on, and they will, if past is any predictor, they will probably release a number of them at the same time so that they can highlight what they're finding and put people on notice as to what they're expecting that they're going to do. And I would expect that sooner rather than later.
Thanks, Mitch. Appreciate that. Okay, next question. This is, I guess, for most of the panelists, and it gets into the nitty-gritty. When dealing with specific clients that have multiple accounts, does this type of analysis need to be taken place on a per account basis or a per client basis?
This is David. I think the part of this is understanding what are you putting them into, right? I mean, if they're coming to you and they have a couple of fee-based accounts, a couple of commission accounts, okay, what is it you're recommending that they do? Are you suggesting that they consolidate them? Are you suggesting a similar mapping over to your firm saying, look, we think we can do a little bit better than what you're doing from a portfolio or commissions relative to the existing structure that you have, but we're going to maintain that existing structure. So I think part of answering that question depends upon what it is that you're proposing that they do. If at the end of the day, you're going to say, look, we've looked at your total portfolio, whatever the other firm was doing is garbage, and we think you should be over here in an advisory program when we kind of do this holistic analysis. I think that can be done as one analysis, to the extent that you're going to have to get into the economics of what's going on at each of the different accounts, though, to justify and back that up. That still involves looking retrospectively at what's been happening at the other accounts. What was the volume? What was the annual commission that they were being charged on? How much trading were they doing? What is it that their objective is with the money that they're doing now? Why is it that making a change to peer advisory is in their best interest now? So some of the answer to that depends upon how you're mapping them over to the new accounts plural structure.
Yeah, I wanted to jump in and add to those comments because I think that it's really important. We're talking about overlapping jurisdictions here. You have FINRA rules for broker-dealers, you have SEC rules for broker-dealers and investment advisors, and then you have ERISA. right? And I think the question that you asked, I would look at it not through a FINRA or SEC lens, but through an ERISA lens. And I think one of the challenges for a lot of compliance officers is many of us aren't that familiar with ERISA. We haven't really dealt with it that much, right? And I think that, you know, we really need to get up to speed on ERISA. So if I look at the question that you asked through an ERISA lens, first, you have to do an analysis. Number one, are you a fiduciary? If you're not a fiduciary, then the answer is you don't need to do anything. Two, if you're a fiduciary, do you have a prohibited transaction? You know, a section, which is typically going to be under ERISA section 406B for self-dealing. If the answer is yes, now can you rely upon an exemption, which presumably is going to be PTE 2020-02. So I would look at the question not on an account or a client basis, but on a basis of, are you a fiduciary? And remember that the definition of fiduciary under ERISA is functional. You are not a fiduciary by title. You are not always a fiduciary. You are a fiduciary when performing fiduciary acts. And so if you are performing a fiduciary act and thus an advice fiduciary, then do you have a prohibited transaction, and then do you need an exemption? And I think that's probably the best way to analyze, you know, that situation as to whether you need to comply or not. Now, that having been said, I'm going to go back to my earlier comment. My policy is you open a retirement account, you need the PTE 2020-02 disclosure. I took all that out of the equation. I tried to make it really easy, right? And I think that the solution that I came up with and the suggestion that I have, it does truly make things a lot easier. It eliminates a lot of this having to go through these analyses.
Thanks, Craig. And there's maybe time for one or two more quick questions. I just saw one popped up, and it's around the necessity to make this type of analysis around IRA to IRA recommendations. Craig, you and I have talked about this a little bit specifically around what triggers that prohibited transaction exemption. Do you want to just quickly touch on that piece?
Yeah, so in the final rule, and actually it's kind of weird because it's the final rule for PTE 2020-02, and it was in the preamble, but the DOL specifically stated that this is applicable to IRA transfers. Okay, and so going through determining, number one, if you're a fiduciary, and what they've tried to do is in redefining when you're a fiduciary, they're definitely trying to broaden their net, and they're trying to ensnare more people as to becoming fiduciary, and trying to you know, have them now be into the compliance with PTE 2020-02. Whether you have a prohibited transaction or not generally will depend upon whether the recommendation increased your compensation. That's the self-dealing. So the typical prohibited transaction is going to be 406B for self-dealing. And if you are a fiduciary and you make a recommendation that increases your compensation, that is self-dealing and a prohibited transaction.
All right, everyone's nodding. Craig, Mitch, David, Josh, we'll squeeze you in there, Travis. Thank you all very much for your time. To our lovely audience and engaged members here, thank you again for taking time with us this afternoon. Have yourselves a great afternoon.
Great, thank you.
Thanks, everyone.
Thanks, everyone.